Good afternoon, ladies and gentlemen. We're glad to have all of y'all with us. This is the Judiciary Committee. We're going to, we got about 10 bills. We'll take them up hopefully pretty quickly. We've got, want to introduce you to Brian Binyuk. Brian, he's right over here. He's taking David Standridge's place. David got moved. As I told David, he got promoted to, I think, state government or county and state government committees. So Brian is from Tuscaloosa. We have one of our two members here from Tuscaloosa that's an asset. We won't call her name or the other ones at this point, but we are glad, Brian, we're glad to have you with us, and it's good for you to be here. Jackson Colburn is here. He is with ALI. He's our analyst today. So we are going to call the roll and get going. Brandy, if you're ready.
Hill.
Here.
Wadsworth. Here. England. Here. Almond. Bedsole. Here. Brinyard. Chestnut.
Here.
Faulkner.
Here.
McClammy. Pettis.
Here.
Robbins.
Here.
Simpson.
Here.
Starnes.
Here.
Stringer.
Here. Tillman.
We have a quorum.
Thank you. We are glad to have everybody here. If you've got an agenda, we're going to take it a little bit out of order because I got a couple of our members that really need to be at different meetings, and I'm going to do my best to facilitate that. So, Mr. England, if you would start and give us HB 16, and then go ahead with 299. If you just do them back to back.
Thank you for allowing me to go first. You want to go ahead and get this out of the way with me and Matt? That's okay. It's time for us to tie it up, I guess. First bill I have is House Bill 16. A couple of years ago, we passed what was considered to be a bail bonding reform act, I guess. And in that bill, we eliminated 3 words. And my bill replaces or returns those 3 words to the statute of definition of cash bail, where it says, it adds back to the language a part of, and it says cash bail is when the defendant or some person on behalf of the defendant deposits cash in an amount equal to a part of the total sum of the bail as set by the judicial officer to the clerk of the court having jurisdiction over the case. So, what the law currently says is that the total amount has to be posted, which it takes away the ability for judges to do a percentage bond, which could be a cash bond. Instead of requiring that defendant to go get a bondsman, the court can actually say you pay 10% cash and we can take that in instead. What normally happens in that situation is when you pay that cash bond, when the defendant shows, because generally speaking, they'll come up, they'll tell you they don't have any money until you lock them up, and then they say, oh, well, if you can give me 10% cash, that money magically appears. Once we get that money, when they don't show up again, we can forfeit it and use that money to pay for fines, costs, and restitution, which is what it's used for in courtrooms all across the state. So what this bill would do would restore the ability for judges' discretion to establish a percentage bond so they can do a percentage for cash bonds. So I'm here to answer any questions.
Anybody got any questions? Yes. Yes, sir. Go ahead, Mr. Wood.
Representative England, the way I was interpreting this bill is that we hear this, all around the country. People say they can't afford the cash bail, the amount that they're being required to put up. As I understand it, it's typically 10% of whatever the judge sets. What I was worried about in reading this bill is that this was allowing the judge discretion to lower that amount, so that we've got people in the whole idea, as I understand it, and granted, I don't practice in this world, but the whole idea of having the bail bond is that you will come back to court and show up. And so you go and have to get that amount of money from whoever, and they're going to insist that you show up for court. And if we allow that amount to be lowered, which I thought this was maybe part of that national debate of saying lower cash bails, and you're telling me right before today we had a chance to speak that I'm interpreting this bill incorrectly. So can you assure me that this is what the current system is, what this is doing, and that this is not some attempt to give judges discretion to lower cash bails down to a level that I think in the name of trying to help people, and I see it as it's going to hurt because they're not going to come back to court?
And that's a good question. First, judges have the ability to issue, if somebody legitimately can't afford to get out, judges have the ability to do OR bonds now, like on recognizance, meaning you promise to come back to court and we can release you with no money, okay? What the law currently does is it removes the ability for a judge to give a percentage bond, which, as you said, is generally 10%. Now, up until this law went into effect, I guess last year, we were doing this all over the state and nobody said a word about it. The reason that we're here now, and I can't help myself, I just got to be honest, is because the industry wrote the bill, the bonding industry wrote the bill, and they wrote it in a way so they could force more people to have to get bonds. But before this bill went into effect, the standard practice for decades was for judges to be able to issue percentage bonds. And quite literally, one of the main ways that municipal courts and district courts get fines and court costs paid is when they forfeit cash bonds to pay fines, court costs, and in fact, restitution. So this will restore the ability for judges to issue percentage bonds and ultimately use the money that's forfeited to pay fines, court costs, and restitution.
So it's restoring the
what we've been doing forever. Literally forever.
And what's the current system is that you cannot do percentage bonds?
Well, with the way that if you remove the underlying language, what it would say is cash bails when the defendant or some person on behalf of the defendant deposits cash in an amount equal to the total sum of the bail as set by the judicial officer to the clerk of the court having jurisdiction of the case. So that takes away the judge's discretion to do a percentage bond. The percentage would be cash of 1,000, 5,000, 10,000, or whatever. So, and to be quite honest, some of the judges who do this stuff more often would often see how much the defendant actually owed sometimes, set that cash bond and impose it, they pay it, and when they don't come back, they forfeit it and pay fines, costs, and restitution.
So this eliminates the
way the law
ability-
is right now, a judge cannot do it. And several judges in my circuit, because in Tuscaloosa County, we use percentage bonds all the time.
And this would eliminate that.
Well, this currently, we can't do it. This would restore it. My bill, with those three little words added, would restore it. So if nobody ever walked up to you in the last 20 years and said that percentage bonds are a problem, that answers your question.
So the discretion on the amount, let's forget the percentage, but the discretion on the amount of the bond, the judges have it and have always had it.
For percentage bonds purposes, yes. Always.
Not currently, then.
But not now.
Yeah, I just want to ask a couple. When did it change? Prior to that bill you were talking about, did it made it where they can make any cash bond so you can pay X number of dollars to get out, and then if they want to modify it, this new bill that was passed a couple of years ago, that made it where they could not modify that.
Judges cannot do a percentage bond because it has to be the total amount.
And this would allow the judges to make a decision what they can pay and then get that money in. So
it doesn't reduce the amount of the bond. just allows the percentage.
Okay, okay. Very good.
Now, you just got here, man. Come on now.
Chris, as you know, I'm a municipal court judge and have been for 24 years, but I've been in Centerville since 2005, and it's a very common occurrence that we have somebody get picked up for failure to appear. There'll be a $500 cash bond. And historically, their mother or somebody will show up and say, hey, I've got 200. I don't have 500 that I can give them, but I got 200 or 300 or whatever. My clerk calls me and says, hey, relatives here, they've got some of it, they've got 300 of the 500. You know, can you reduce the bond? And historically, I've said yes. Are you telling me the law changed on that last year?
100%.
Wow. Let me tell you, there's still probably a ton of people still doing that.
Oh, and they are. And what also brought this to light is that there were bondsmen going to courts threatening them with the law, saying that you can't do that anymore.
We need this bill.
Well, I mean, it's literally how municipal courts and district courts are funded, and that's literally at times the only way you can get money from fines and court costs.
Thank you, Mr. Chairman.
Anybody else? Ms. Alderman, if you'd like to chip in, we'll have 100% of the Tuscaloosa delegation.
I was helping Mr. Faulkner out, so I think I did my part.
We appreciate it. All right, any other questions? Is there a motion to give this bill a favorable report?
I move.
Is there a second? Second. All in favor, say aye. All opposed. Okay, Mr. Raymond, thanks. You get a favorable report.
Man, this is getting harder and harder for me in here, man.
Okay.
Um,
Go with HB 200 while we got.
all right.
299, I'm sorry.
All right, thank you. Not sure if this is going to be controversial or not anymore. I'm just, whew. All right, this is House Bill 299. It's a compassionate parole bill, and I brought it last year, and a lot of suggestions were made, and we took them. Last year, the age threshold was 50. We raised it to 60. You have to serve at least 10 years of your sentence, and this is not a mandatory release in any circumstance. The discretion still rests with the parole board in the decision to determine release or not. But what it does, it just gives weighted consideration for age and also weighted consideration for health condition, and also it reduces the amount of set-aside time once you get over 60 years old from 5 years to 2 years. So you can be reviewed every 2 years, considering if your age and your health condition. So that's it in a nutshell. I'm here to answer any questions I can.
Okay, so help me out with this, with that last part, throws a wrench into this process. If you're 60 years old and you're convicted of murder and you're serving a period of murder and you're up for parole, would this require you to become up for parole every 2 years now instead of every 5 years?
You couldn't set it off for 5 years.
You couldn't. You could only set it off for 2.
Yeah. You
So if
keep
the
reviewing.
victims came up to oppose that a family member was killed, and the victim came up to say, hey, I do not want this person out and paroled, now instead of having to come up every 5 years, that victim would have to come up every 2 years, correct?
If the victim wants to come and protest release, yes.
Thank you, Mr. Chairman. Representative England, Reverend Stinson was touching on it. This requires, reading your summary here, a person convicted of a nonviolent offense with a sentence of 20 years or less, the board shall usually is used, shall reconsider the prisoner's release on parole within 2 years?
Yes.
And currently?
Well, the limit is 5. The current parole board has made it pretty much a custom that everybody who's denied parole gets the general 5-year set off. And the reason it's different here, obviously, is because our prison system is turning into healthcare system for older, wiser Alabamians. I don't want to insult any older, like Judge Hill. I don't want to insult anybody. So, but
Motion to subcommittee?
well, what the point is, it's. Hey, look, that's what I'm trying. But the point here is, a smaller percentage of the population continues to grow, balloon. They become more expensive to take care of. Over the course of several years, they become less of a risk to public safety. It becomes a point where it costs us more to incarcerate than it does to care, and they can be better served outside, especially when they've demonstrated that they're not a threat to public safety. Consideration to age, and if 2 years is too short, and I'm open to an amendment to change it to 3. I mean, that's not a something to say. No, that's not something that I'm not willing to negotiate and listen on. So
When it's nonviolent offense, is that defined in here?
yes, that's already defined. There are certain offenses that you allegedly can't go to 5-year set aside, although it still happens from time to time.
Is nonviolent, what about is it use of a firearm? What do you mean by nonviolent?
It's a statutory definition that's already set.
Yeah, I don't have that.
And it's a number of different things, like depending on the circumstances of the offense, but we're talking generally about drug offenses, property offenses, things that don't require that the victim wasn't harmed, weapon wasn't used, except for like things like burglary and something like that. So
I think if you could, I'd like to know.
I can tell you what the violent offenses are, like rape in the first degree, kidnapping in the first degree, murder, attempted murder, sodomy, sexual torture, robbery in the first degree with serious physical injury, burglary in the first degree, arson in the first degree. Those are the violent offenses. So generally speaking, everything except that.
Okay.
I do. Basically, if it's 20 years or less, is 2 years is when it come back up. Correct.
Right.
Can you give me a summary of when a violent crime would be put out? Give me a summary of when a violent crime, when they'd be eligible for parole in or hearing in a violent crime.
I think it's 15 years, I believe, isn't it? You have to serve it on a violent offense. You have to serve at least 15 years of your sentence. And this bill would create a different pathway for somebody who's over the age of 60, served at least 10 years, and also has a health condition. And again, it doesn't force anything.
Is it just changing from 15 down to 10?
Yeah.
And they have to be over 60 or older and have been in prison for at least 10 years.
Correct. And again, some of those things we're not wedded to. If 10 is not enough, maybe somewhere between 10 and 15 or something like that. But just trying to identify a population that can be safely released because they're no longer a threat to public safety and are costing more to take care of than to incarcerate. Again, those are sorts of things that if you had an amendment that you wanted to introduce, we would certainly entertain it. But again, the spirit of the bill is to deal with age, health, and also as long as you served at least 10 years of your sentence.
Representative England, I've got just a couple of questions. I was kind of wondering, reading over the bill, that you don't really change much in the medical furlough part, but in the medical furlough, it says that you would get a report from a physician that's employed by the department, and then also a notarized report from another licensed physician. So you get 2 medical reports, where then and I kind of wondered when I was looking over the new language on page 11, it just says, as determined by reasonable medical judgment. So I kind of wondered why it seemed like we lessened the medical advice on the parole and left the 2 doctors in place for the furlough, and maybe why not just kind of use the same thing where you get a doctor from the department to say, yes, this person is incapacitated and could fit, and then you get an outside doctor to say, yes, I agree, this patient or this individual should get medical release. So it kind of matched furlough part.
Well, if I'm not mistaken, I think the furlough part doesn't deal with the parole board, right?
It doesn't, but it's just
Yeah,
it's
so-
the accompanying paperwork, I guess, is what I saw, where you could say, all right, we've got 2 medical professionals that say this individual needs to be released. Is all I'm thinking. Why not do that? Because I know that's like with, a living will or medical directive. It's once 2 doctors say this person is incapacitated, you can pull the plug, or those kind of things where it's 2 doctors that. So there's always that risk of one doctor just being wrong.
Well, I mean, that's something that we could add to the weighted consideration that goes forward, like more evidence to indicate that this person is in fact medically fragile or infirm that could weight towards release. So, I mean, I don't think necessarily that would be an issue, but the reason that it's required on furlough is because it's really just it's an internal decision that the Department of Corrections is making.
Right. Yeah.
So there's more of a checks and balances on that. But as far as like adding that to the list of considerations that go that go along with the inmate to the parole board, I don't think that should be much of an issue.
Okay. I didn't think it would, but and then I was reading on page 11, on line 300, where it says that when you get denied parole, the prisoner or an individual acting on the prisoner's behalf may appeal. So does that mean that non-attorneys could somehow file the appeal?
Yeah,
or
unfortunately, we don't give post-conviction relief. Part of that's not an attorney, so some of these cases would require somebody either representing or the inmate themselves to file it, because honestly, it would be very difficult for somebody who's been in prison that long to have an attorney to do some of that. So, in order to do what we do, just like on Rule 32s and other things, where an inmate can file their own, this is similar language.
Okay, I'm going to pull the David Faulkner here. I don't practice in this area, but I just wondered why it seems like you wouldn't be afforded a court-appointed attorney to handle. I'm just talking about adding expense, unfunded mandate, but you wouldn't have court-appointed attorneys to represent you in the appellate process.
No, not in Alabama.
Okay.
Not only that, in a parole process are you appointed?
You're not.
Mm-hmm.
Yes, sir. Mr. England, you may have provided this to us last year. I'm not trying to slow down your bill. If you get it voted on today, then just ignore my question. But if not, and while this is not just a financial decision, do you have any data on how much money this saves or would save or could save our prison system if 75% of these people were?
Actually, no. I could get that for you, something to better quantify that. But I mean, just to give you like an example or two, we recently had someone that went before the parole board last year that was on dialysis, over 60, served a long time, which, if we're going to dialysis, that means you're leaving somebody. I mean, that's pretty expensive. And that person was denied parole. They're still in. So we're paying for the cost, even though we know that person is not a threat to public safety. But I could actually get a better number for you to get a better idea of how large that population is, and try to give you the numbers on how much it costs.
I think it's worth a try. It would be interesting to know. Again, it's not a total financial decision, but it's certainly a component of it. Thank you.
Starnes, you have a question?
Being asked the question.
I can actually probably get those from our sentencing commission.
Wait, you got it? Okay, got it.
Before-
Roll call.
before-
You have a question?
I just have a question. It seems like we're making several changes to this, and it felt like before we have a vote on it, we probably need to have the bill drafted with some of these potential changes. And I'm gonna move for send it to criminal subcommittee for a discussion of the changes on here, plus maybe even adding an educational component to this.
Okay, do I hear an objection? You want to go on subcommittee? And I'm going to say Criminal subcommittee, I want y'all to know, I'll put it back on next week. Because I want to give this a hearing.
I understand you want to give it a hearing. I've got no issue with that to go through it, but there are a lot more issues that I have that I don't think a subcommittee will be able to handle, just so you know.
Well, Matt, you do have options.
Well, now you got me started.
You can go vote. You can just vote no.
I can vote no, and that's what I'm going to do. The issue that I have, if you look at line 280, and I'd address the members of the committee to look at this. If you look on page 10, starting at 275, it's anyone convicted of a nonviolent offense is required to come up. If their sentence is less than 20 years, then they are required to come up every 2 years instead of the 5 years. The problem that I have is if you look on line 280, is that any prisoner denied parole who has served at least 10 years of his sentence and has reached the age of 60 shall have a reconsideration regarding at least every 2 years following denial. This means if somebody is 60 years old and has been convicted of murder, they shall be heard every 2 years. If somebody's convicted of rape, they shall be heard every 2 years. If somebody's convicted of kidnapping, they shall be heard every 2 years. So every time you're having a victim that's going to have to come back up that wants to be opposed to somebody getting parole, they're going to have to come up every 2 years and relive that to have to go through to fight through this process. So that's my concern with the bill.
If you read the first sentence of the previous paragraph, it says if a prisoner is convicted of a nonviolent offense.
Yeah, it does say that in the first paragraph.
Subsection 2 follows that to further define what happens there.
Nope, it doesn't. I don't agree with you on that reading because subsection 2 says any prisoner. If you look under subsection 2, line 280, it says any prisoner.
Did you mean any prisoner denied parole subject to this act?
Yes. But, I mean, again, since it's going to subcommittee, I guess we can further define that language. But, yeah.
Thank you. Mr. Bledsoe, you want to go 359?
All right, thank you, Mr. Chairman. Members, what I have before us is HB 359. This is another step in our, I think, what will be a long journey as we continue to address mental health issues in our state. As you well know, the mental health crisis is real, and we deal with it on many levels. This bill addresses a few of those issues, and I'll try to go through them as quickly as possible, but I want to make sure we all are hearing the detail and the problems we're facing. HB 359, issue number 1, mental health problems often coexist with substance abuse type issues. This will address the definition to include substance use or abuse that will help in the aid and treatment of those with mental health disorders. As we possibly have funding available that would help in that area, that this will help that funding be applicable to mental health issues in the future. This bill also defines co-occurring substance use disorder. It adds a definition to the serious mental health, or SMI. Issue number 2, the law requires a commitment petition to be filed in the county where the individual is located. The probate judge must, after that, order the sheriff of the county in which the individual is located to serve a copy of the petition. Sometimes these individuals will travel to another county before the order is issued to the sheriff. And because the probate judge does not have the authority to order another county sheriff to serve the individual the petition, service cannot be accomplished. This bill would clarify that the location of the individual at the time of the filing is what matters, not necessarily where he or she is subsequently located. Issue number 3, for temporary orders, the current law contains an antiquated requirement that the sheriff bring the respondent before the probate judge. Physically bringing the individual to the probate judge is not always possible instantaneously, especially if the individual is in a hospital or is otherwise being medically evaluated. The solution here is before issuing the temporary order, this bill would provide that the probate judge with the decision either to order the sheriff to bring the respondent before the probate judge or to interview the individual, officers, or other available persons to seek an evaluation from a licensed medical physician or qualified mental health professional. In the last issue, some individuals with active commitment orders have been arrested for misdemeanor offenses or municipal ordinance violations, such as disorderly conduct and public intoxication. And I can tell you firsthand, usually goes hand in hand. If you have a mental health issue, you often see disorderly conduct or public intoxication charges. While waiting on bed space resulting from them being taken to jail instead of a mental health facility, once an individual with mental health is in law enforcement custody, our probate judges have lost jurisdiction by statute to be able to continue to supervise or manage their case, if you will, leaving the probate court with very few options. And I can again tell you from personal experience of running a jail, we've ran into that more than one occasion. So the solution here is when an individual has active commitment order or is confined solely for a misdemeanor charge or municipal ordinance, the bill as amended would improve communication between the probate judge who issued the commitment order, the municipal court, district court, and circuit court who ordered the confinement. Essentially, this bill will allow for a very effective means of communicating between those different courts so that we can give the individuals the mental health treatment that they so desperately need. So that's a summation of the bill. I also have an amendment to kind of clean up a little bit of a language that we want to make sure is very clear.
Let's go ahead and do your amendment. Let's get it all in one place.
Okay. So if you'll turn to page 15, lines 411 through 417, the amendment will provide it that read, Judge of probate who issued the commitment order may communicate rather than petition, communicate with the judge of the district, municipal, or circuit court who ordered the respondent to be confined to discuss whether he or she will issue an order to discharge the respondent from confinement and suspend the criminal proceedings temporarily so that the commitment order may be fulfilled. So adds in the word communicate and ensures that all levels of courts are included, district, municipal, and circuit.
Any questions on the amendment?
I have a question on the amendment. Would you be amenable to allowing the prosecutor to be involved on these conversations? I would have a little bit of a concern about, and I'm supportive of your bill and what you're trying to do. I think I'm a co-sponsor on this bill, as a matter of fact. I understand what you're my concern is if you would have a potential situation where a probate judge would reach out to the circuit judge and have them make a determination as to releasing someone from confinement without having the prosecutor have input into the situation on the case.
Yeah, I think a wise approach is always to have all parties involved in this. I think if that's what our goal is here, is to ensure that we have that communication. I think communicating them, now I don't know what you have in mind for a way to add that amendment in to ensure that communication happens, but I don't see why working with a prosecutor so that they're aware. They should be, because it could change the direction in which that case goes.
Right. I don't know what language we can do. I don't have an issue with this amendment, and perhaps on the floor, would you be willing to take some type of amendment on the floor to, I can work with some people that can draft an amendment to do that.
Yeah, I think placing it correctly would be very important. So yeah, absolutely, we can work on that.
Yes. Would there be a problem, Mr. Simpson, in that league group of people, DA, adding the term prosecuting attorney, where you've got district, municipal, circuit court, or prosecuting attorney? Because sometimes you're going to have city attorneys. You're going to have city prosecutors involved.
My only concern with that, and I'm trying not to lose the committee here, is the word may. I would like the prosecutor to have to be notified of what's going on in those situations instead of may.
Judge, I got a question.
Okay, go ahead.
I'm not trying to muddy it up even more, but in terms of due process and some of those issues, if we're bringing the state or the prosecutor involved, does the defense attorney for that individual or the attorney that was handling the commitment need to be a party to this hearing if the state is there? Because then it's in essence become a hearing, and so you don't have the defense attorney there. And so that way both sides are there making a case, in essence, making an argument.
I've had a discussion with my probate judge and with my circuit court judges about this that have handled mental health court through this process and some of the stuff through. I think it's a great idea. I think this is exactly what we need to do to allow this communication, but I do want to make sure that the parties have an opportunity to be heard on a situation like this.
I mean, I do too. I just would hate for a DA or a prosecutor to be there and then it be decided, no, we're not going to work, and then someone file an appeal. Well, I wasn't able to have counsel at this meeting when the state was at a quote unquote hearing.
I don't practice in that world either. So My experience is that that the prosecutors are going to be ever mindful of not to do anything that's going to harm their criminal case. So in most instances, if there's any discussion going on with their clients, the prosecutors would loop in the defense attorneys, whether it be public defenders.
I mean, I would agree on that end, Russell, that I don't think the state's going to do anything to harm their case, but if you're having meetings with an attorney or with the judge and the prosecution is there, you have to have the other side there. So if we're going to add the prosecutor, I think we need to add defense just so I think that's just adding another comma.
Yeah, I don't have a problem with that. I would assume that would already go on. That would be good law school practice, I think.
Don't assume.
I have based on our communications in the past many times, and as well with Representative Robbins, I feel like we can get this resolved and make this something that we can get fixed. I am not intending to slow your bill down, so if you're willing to work with me before it gets to the floor, I would be willing to work with you on a floor amendment to get this done.
It's not a problem.
All right, let's do this. On the amendment, you've offered the amendment. Is there a second to adopting that amendment? Thanks, Mr. String. All right, so there's a motion and a second. To adopt the amendment, are there any further questions on the amendment? Seeing none, all in favor of adopting that amendment, please say aye. Aye. Any opposed? Okay. Back to you, Mr. Petzold, on the bill as amended at this point. Is there anything else you need to add?
No, sir. I'm happy to answer any further questions.
Yes, sir.
I just want to make a comment, but while they're in probate court, they're going to have an attorney because they'll appoint an attorney for the defendant in it. And I think all you have to do is just serve notice of that proceeding to the defense counsel, and the defense counsel can come if he chooses to, or he can let the attorney that's been appointed in the probate court handle it.
Yes, sir.
You know, in an involuntary commitment, if you'll think about it, one of the key words here is involuntary.
Yeah.
Meaning that you have to have an individual that advocates for the commitment, and you also have to have an individual that advocates for the individual who we seek to commit. So you've already got those people in place, and I think I'm with you, Mr. Simpson. Anything that we do like this, I think we ought to loop everybody into it so everybody understands. And the only comment I've got, Mr. Betzold, is this. This is great, and this is what we need. Like you, I've seen so many times when there were codependent, you know, it's a mental illness issue, but it's also a substance abuse issue. You know, just sort of as an aside, what we're not dealing with the fact that we don't have enough mental health beds in our mental health facilities.
That's right.
To facilitate the people that we are trying to commit today, much less as you increase that, although it needs to be increased. What you're doing here is addressing the problem. We also need to do our least, make some effort as a legislature to address the solution.
I think your comments are right on. We had conversations before the committee today. I mean, I've seen it firsthand many times. There's certain individuals, no matter how hard we've tried to reacclimate them to society, give them all the services and programs, they can't be housed in society. We have to find a way, the right way to do it, where we have that adequate space. So, and Judge, real quick, if you'll do me the pleasure, I would just like to say I've had my probate judge from Shelby County, Judge Allison Boyd, in attendance today. She worked hard with this as well. She's an expert in the field and does a tremendous job. So I just want to publicly thank her for all her hard work and what she did to put some good words here on the page.
There's no question. Judge Boyd is one of the best we've got in the state of Alabama in this and in other areas that deal with probate law. We're glad to have you here with us. We really are. Okay, there's a, yes, sir. How about just a second? I'm gonna let Mr. Betzold do his own motion. He's done it. Motion and for as amended, second. Any further questions? All in favor, say aye. Aye. Any opposed? You get a favorable report as amended. Thanks, Mr. Betzold.
Thank you, committee.
Judge, you're not going to believe this, but Judge Boyd and I were in law school interns at the Shelby DA's office together. So she's heard my spiels and speeches a long time.
That's interesting because wasn't James in law school with you? I never heard him mention Matt. I heard him mention you innumerable times.
If we're announcing special dignities, if you don't mind, Judge, I would like to recognize before they leave, I have 2 county commissioners from Baldwin County that are present for the committee that decided to sit in a judiciary meeting for some reason and punish themselves. Commissioner Jeb Ball and Commissioner Billy Joe Underwood. I want to thank them for showing up and understanding that we're trying to fight for funding for mental health beds, not just pushing it off on the counties as well.
Well, we're glad to have you with us because we recognize that a lot of the things that go on in our system oftentimes impacts your county jail, and there's no question that that's true. Thank you for coming. Appreciate your concern. Okay, back to the top. Senator Jones, how about 153?
All right, thank you, Judge, members of the committee. This bill has to deal with expungement. If you'll notice on I believe it's page 3, you'll see the only change there. All of these things are expungible, but somehow through an oversight, I think a YO for those same offenses is not. We found this is coming from a constituent of mine who had this issue. So simple change.
Okay. Any questions for the senator on 153?
Well, Mr. Chairman, I just wanted to thank the senator for this bill. I think it is a good bill, and I appreciate your efforts in bringing it and the work you put into it.
Thank you, sir. I'm looking for a house sponsor, so I'll throw that out there.
I think you just got one. All right, and I like you. I tell you, expungements and these things can be very helpful to these individuals because it gives them a better opportunity to better start, right? And that's what you're trying to do. All right, ma'am.
This is just a technical question. I'm sorry, but so if you're adjudicated youthful offender, it's not an actual adjudication of an offense, right? So can you expunge it?
Yeah,
technically?
I can answer that just to help you guys out. You're adjudicated as a youthful offender. That is the offense you're adjudicated of. So yes, you do fall under the offense of youthful offender. It's not the offense of the crime that you committed.
Okay, so you can still expunge that. Okay. Thank you.
Okay, is there a motion to give Senate Bill 153 a favorable report? Thank you. Is there a second?
Second.
Okay, any further discussion? All in favor say aye. Aye. Any opposed? Senator Jones, you got a favorable report. We appreciate your effort.
Thank you, Chairman and members.
Stewart, you doing Stewart's? Yes, ma'am, please.
I am carrying this bill for Senator Stewart. Is anybody here from the Department of Labor? Yeah, great. Correct anything I misstate, please. But this is the Department of Labor bill, and I believe it passed unanimously upstairs. Basically, it updates its existing child labor laws. It strengthens the civil penalties in a couple of different code sections, and in 2 sections, it changes the word may impose a civil penalty to must impose a civil penalty. And that's pretty much the gist of the bill.
Okay, and
Take any questions?
yeah, any questions? Any questions?
Mr. Chairman?
Yes, sir.
I have a different understanding of this bill, and the penalties do not appear to be way harsher than anywhere in the country. In looking at this, we couldn't find any state that had this type of penalties for child labor laws. I would like to have an opportunity to, put this in a criminal subcommittee to look at that because, and bring it up, Judge, because of these penalties just are off the charts compared to anywhere else. and you can see the increases there are,
We went from 1,000 to 5,000.
it takes the punishment for child
10,000.
labor law infractions that result in a serious injury to a child up from Class A misdemeanor up to a $6,000 fine and a year in jail to a Class C felony, 366 days or up to 10 years in jail, and then or a Class B felony from 2 to 20 years in jail. So it was a heavy increase on this. You know, there's been a get more participation in the workforce. I guess I'm just concerned that we couldn't find anywhere in the country where the penalties had gone up this high.
Okay.
And what the reasoning was.
Would we like to hear from the Department of Labor while they're here in response, or?
Yeah,
okay.
just a second. But Mr. Chestnut, go ahead.
Yeah, I in Coleman,
I believe it is, yes.
where the roofing contractor and 15-year-old ended up, you know, falling several to his death. I think this is what the response to that.
We have somebody here from the Department of Labor? Please. Sir.
Hi, Arthur Ray. I'm the Assistant General Counsel of the Department of Labor, also Director of Governmental Affairs for the agency. And I also, in my capacity in the legal division, have worked with our child labor inspectors and have worked cases with them or supervised them working cases. And Mr. Faulkner, to your point, we did two things in this bill and that the senator was helpful with us on. First, we actually changed the language in the first section to give our discretion back. The shall language was put back to may so that our child labor inspectors could go to somebody. A fairly innocuous offense that we run across often is somebody works at that age bracket 2 hours over their shift. It's a violation. But there's no reason to go in there and slap a $1,000 fine on or a $300 fine on them, making it mandatory that we do that. So instead, the child labor inspector can go in and say, look, you'd be subject to this penalty, don't do it again. And 99% of the time, they don't do it again. So the first part of the bill works that way. The second part of the bill absolutely was my understanding was a reaction to what we've seen out in the field, which is absent some kind of significant punishment, you would be stunned at the numbers of underage children, often, coincidentally, migrant workers of various status, who are put on roofs or put in chicken plants with no safety guards on it. You know, just all kinds of prohibited and statutorily prohibited jobs. You know, we have a long laundry list of prohibited jobs, and our guys stay busy out there finding children, and I stress the word children because they are, in these positions where they easily can be harmed, maimed, or killed. And so, you know, you have to weigh the punishment against, you know, the exposure, which, you know, in the legal profession, we do that all the time. We take, you know, punishment versus exposure, cost versus benefit, however you want to phrase it. But we definitely see these violations out there. And so we did not see anything untoward about it. Now, obviously, I think the senator would probably be open to looking at it, but I don't know that anybody's done a, you know, kind of a cross-state analysis of it to see how either commensurate with other states or off this is. It didn't strike our people as untoward.
Okay, was this a Department of Labor bill? It was that y'all asked for the senator to bring this bill? I mean.
Yeah, oh, in the sense that we drafted it initially or brought it up initially?
Yes, yes.
Now, I think we were made aware of it after he had done the drafting, and so we've worked with him on it.
Okay, you have worked with him on, okay, but and we did.
And that's how we got that initial language in the first section changed so that would give us back our kind of discretion, if you will.
Okay. Well, we did take a look at around the country, and it was, I don't think there's anything, like this in terms of the felony and the amount of the fines and stuff. So, yeah, I probably would want to sit down with him.
Sure.
Robbins, Judy, question?
Thank you.
I did have a question.
And I don't have any problem, obviously, going to subcommittee to look at the comparison.
Kind of had a question for labor, if that's okay. Yes, sir. So I assume that y'all were involved in the bill we passed yesterday about child labor and how we kind of, in essence, freed up, allowed more minors to work was, in essence, the bill that we passed
It
yesterday.
was 102 that had to take the permission slips out.
Yeah, but you no longer had to go through the school system to get permission.
Correct.
Some of the parental requirements were removed.
Yeah, our position on that was we had seen it as kind of an unnecessary restriction, kind of an extra layer of bureaucracy. And quite frankly, the principals, I think, were glad to be out of it. And on top of that, nobody was complying with it anyway, just to be blunt.
Right, so I was kind of wondering what the, it's kind of interesting what the interplay would be, because on one hand, yesterday we just said we want more children working, and then today we're saying we want to be more punitive to you if you employ children and they get injured.
If you employ them in the prohibited profession, job categories, because this is specific to prohibited job categories. And so if you work somebody in those prohibited job categories, then you're subject to these fines and penalties.
Right. Well, I know that, I know that 25845, that code section, we amended it yesterday. So I know that there would be some interplay there, because that would be, we've amended it. So the bill we had yesterday was related to 25845. So
right.
There, if you violated that, well, we amended. So I guess what I'm kind of curious then, if we want more children working, and I'm not encouraging, could you even get insured to employ children? Because your costs would be so high as a punitive aspect that no one would underwrite you if you employ children. So I just kind of wondered how the two would work together, but.
Sure, yeah, and that's, like I said, we just don't want them in those prohibited classes, in those job categories, and again, those are statutorily mandated.
Right, and I as ignorance, but is there any way, I guess it's all those code sections, but could we get kind of an idea of what those prohibited jobs are?
I have a list here, so it's like the selling of fireworks. It is prohibited from working in any sandpaper or wood polishing machinery, any washing, grinding, or mixing machinery, or commercial laundry equipment, any place or occupation which the department declares dangerous to life or limb or injurious to the health or morals of individuals under 16 years of age, etc. Things of that nature.
Would you mind sharing that list?
Yes.
Reason why I ask, I've got a 16-year-old. He works 2 jobs. He works at our church, and he also works at the movie theater. It's hard enough. I'm trying to establish a work ethic so that way he knows what he can do. Would those be any of those prohibited jobs that they would have to do?
No.
Okay, so they can continue to work in fast food or retail or any of those type of easy.
Yes.
Okay.
Okay.
Well,
Mr. Trotter, do you still want this to go to subcommittee? If you do, I'll put it there.
I think so, Mr. Chairman. I just would like to take a little deeper look at this if Representative Almond's okay with that.
that'll be fine. Fine, and we have Senator.
Well, Senator's here now.
So his question was, in particular, he thought this was the fines and penalties were out of line with the rest of the country, and he wanted to take a look at that.
Yes. Mr. Chairman, may I be recognized?
Sure you can.
Thank you for this.
Senator Stewart, it's your bill.
Thanks. But I'm in your house. I want to be respectful. And so I want to thank Representative Allman for the dialogue and for you carrying this bill. Was in other meetings, ran downstairs. And so, but I just wanted to share that this isn't a controversial bill. This is a bipartisan bill that we did in the Senate. because we realized while we're striving to increase workforce participation, and it is worthwhile for children to work. However, children are our most vulnerable demographic, and we need to make sure that we have safeguards in place as they're entering the workforce, that they're able to live out their full potential. Representative Chestnut spoke earlier about how we've had in our own state, current state, a tragedy recently where we had a 16-year-old or 15-year-old die in a roofing accident. And so we need to be proactive. I think Representative Faulkner, you asked about, did the DOL ask for this bill? Well, I spoke with leadership with DOL, and they are in support. They think that the fees are too low and that we need stronger deterrence, especially if we have another child labor bill that sort of removes the bureaucracy with the sign-offs from the school system. However, we don't want employers to get the wrong idea that we're going off rails with our safeguards. So that was the reason why we wanted to bring this bill to fruition. And so I do welcome amendments, but we don't have much time legislatively. And so I want to make sure that we as a state are standing up for our children, not just saying, oh, we want you to work by any means necessary. Does that clear up everything?
I don't think, Senator, up to a point, it absolutely does. However, there's a request that I put this in a criminal subcommittee. I'm going to do so. However, I put that in for them to work on this, and I will have it back up for you next week.
Can I have just one little question for you?
Sure you can.
This sounds, I know they're putting criminal punishment into it, but this sounds really civil.
Mm-hmm. Really does to you.
It really sounds.
So you think Mr. Faulkner should get it? Is that what you're telling me?
I think a lot of civil attorneys would know the better on the labor law issues than a lot of law enforcement.
I got one going to criminal. This one can go to civil.
I would say I disagree. Representative Simpson, since he's been on such good behavior for ethics, I think we really need to just let him loose.
Agree.
And just take this bill on.
I agree with Representative Robbins.
Yeah, well, good for y'all. Civil subcommittee, and but I tell you this, I want it back up next week because I do agree with the senator. We want to encourage people to work. We want to encourage people to work safely, and that's common sense, right?
Very much so. And I look forward to the continued dialogue, Mr. Chairman, as well as with Representative Simpson, Representative Faulkner, my Selma best friend, Rep. Chestnut, because he's a great legal mind as well. Thank you.
Thank you, sir. We appreciate you. HB 39, Representative Van.
Thank you, Mr. Chairman. Members of the committee, you have before you HB 39. HB 39 is a bill relative to virtual kidnapping. It creates the crime of virtual kidnapping when any person threatens to confine, restrain, or injure another, or claims they have already confined, restrained, or injured another, and makes the threat or claim for the purpose of obtaining control over the property of another. Virtual kidnapping is a deceptive tactic by cyber criminals, and they're used to make an individual believe that a loved one or a person, to their knowledge, has been kidnapped. It seeks to take advantage of someone's fears and panic by using technology to create a realistic illusion that an abduction has taken place. It is a scam, typically being that begins with the use of a cell phone or some type of computer or apparatus or platform, calling someone's family members and using some type of tactic to make them believe that that person has been held captive. The caller may allege, for instance, that your daughter or your son has been kidnapped, and you may hear a screaming voice that appears to be your child or that particular individual screaming in the background. Another variant of this fraud has a family member being held because he or she caused an automobile accident or some type of injury or is injured and won't be allowed to go to the hospital until damages have been paid. These callers typically provide the victim with specific instructions to ensure a safe return of a family member if all of their demands have been met. And if passed, this will create the crime of virtual kidnapping, which will be classified as a Class C felony here in the state of Alabama.
Representative Simpson, go ahead.
Representative Gavina, I understand where you're coming from with this, and I really agree with where you're coming from with this, Ash. Let me ask you this. Under this scenario, if someone is calling from a prison cell that says, hey, we are going to injure or hurt someone else's family member that is also in a prison, would that be something that would be considered a crime?
I think it would. I don't think we differentiate with crimes even when people are in prison. So this should be no different than any other crime.
So this could be a tool that is used very strongly in our prisons to be able to prevent people from suffering the extortion and other family members have to suffer in their prisons.
Absolutely.
Okay.
This is beginning to be a serious issue, especially with our youth across the country. We want to definitely make sure that we are proactive in these efforts. And I want to thank you, Judge Hill, for putting this bill on the agenda. I was about to say calendar today, but
You're welcome, man. Any other questions? You know, it's interesting because of the word that you just used. When I read this, I wrote down extortion.
and I meant to say it's really a form of extortion.
It sounds like a methodology by which you extort money through a threat that may or may not be true.
And actually, there are so many cases now that are moving rampant throughout the country. And not only that, it's also having a cause and effect on individuals' health, because if you're thinking your child or loved one has been hurt or kidnapped, some individuals have gone into cardiac arrest and suffered strokes as well as other illnesses as a result thereof.
Mr. Faulkner?
Representative Van, did the DAs, have you heard from the DAs or worked with them on this bill at all?
No, and I have not heard any objection. And I usually, whenever I come here, I always bring a bill, and if there are any objections, someone from the DA's association will reach out, but they've not had any issues. They want to be as proactive as possible with this type of crime.
Mr. Simpson?
Mr. Chairman, I make a motion for a favorable report.
Okay. There's a motion for a favorable report. Is there a second?
Second.
All right, thank you. Got a motion and a second. Any other questions? All in favor say aye.
Aye.
Any opposed?
I appreciate it. And
Man, we
Mr. Chairman, if I may add, it should be a crime for this room to be this cold. My toes are frozen.
Amen.
We'll try to get you up quicker next time.
Oh, no.
All right, Representative Clark, how about HB 100?
Thank you, Mr. Chairman, and good afternoon, one and all. I am here to ask for a favorable report of House Bill 100. It is it proposes to amend Section 17330, which is known as the Felony Voter Disqualification Act. If approved, this bill would do two things. It would establish increased minimum penalties for a felony committed against an election official that is motivated by an individual's role as an election official. If approved, it would establish that a felony committed against an election official, which is motivated by an individual's role as an election official, is a crime of moral turpitude. Now, according to NCSL, the National Conference of State Legislators, nationally, election officials have faced an unprecedented level of threats to their safety in recent years. Some states have passed poll worker protection laws. However, in working with LSA on this particular piece of legislation, I realized that generally we already have laws in place to deal with most crimes. So we looked at, instead, the Felony Voter Disqualification Act. It currently includes 48 felony crimes of moral turpitude. And those crimes would cause you to lose your right to vote as a citizen. So if HB 100 passes, a person who is found guilty of a felony against an election worker would lose their right to vote. And I hope the prospect of the loss of your right to vote would help to deter folk from committing crimes against election workers. We depend so heavily on them at election after election. They get a little bit of money, but not a whole lot. I think in Mobile, the training that they're compensated for is maybe a mere $15. So we need to do all that we can to protect our election workers, and I ask that you give this bill a favorable report.
Any questions for Ms. Clark? Yes, sir, Mr. Farmer.
Representative Clark, I noticed one difference in this and the bills around the country is that you've included poll watchers, and you've upped the fines and the penalties
from the minimum, yes.
And in comparison to other states, and would you be amenable if poll watchers are not included in this, or? I mean, as opposed to actual election officials who are paid employees, election officials. I was just going to throw that out there to you.
And we would leave poll workers.
Watchers,
We would leave poll workers in the bill.
Yes, ma'am.
But take out poll watchers.
Yeah, we're talking about paid. I mean, I think the intent of your bill, and that I've seen from other states, is you're talking about election officials who are, they're paid to be there by the government as opposed to poll watchers.
I understand the distinction. Typically, the poll watchers are volunteers for us, candidates, as opposed to poll workers being hired by county and municipal government. I would consider that a friendly amendment.
Okay. All right. Well, I was just wanted to throw that out there to you. Yeah, if you want to do it now, or I can work with Representative Clark, but it might be easier to do it in committee.
I'd rather do it now.
Okay.
Thank you.
I mean, I just soon get it. Listen, let's get it done. Let's get it cleaned up where we are.
I thank you for your patience thus far, Judge.
Representative Almond, do you have a question?
Yes, Ms. Clark, as I understand from Representative Faulkner's question, there are other bills similar to this across the country. Do they also include this being a crime of moral turpitude?
Honestly, I don't know of any other states that have crimes of moral turpitude.
That's just something you came up with?
Oh, no, I did not come up with this. The Alabama legislature came up with this. The Felony Voter Disqualification Act. Does anybody here remember what year that was passed? I've been here 11 years, and I know it's been a while.
Well, we've had crimes of moral turpitude probably for as long as the state's been in existence.
Okay, thank you.
I guess
I just remember voting on it during my tenure, which has been 11 years.
Generally, we consider felonies or crimes that involve your character are generally crimes of moral turpitude. Theft, murder, those kind of crimes are always moral turpitude crimes. So you may have a better list of them, but basically it's crimes that involve someone's character that we deal with.
It's a lot of like your perjury, your things of that type of nature, yes.
Yes.
Fraud.
So I guess my question is, how does this, while I think this is doing something to somebody who's working at the polls is a terrible thing to do, I don't understand really how it's a crime of moral turpitude is my question to you.
So as I stated earlier, most crimes, if not all, are already on the books. And penalties, a range of penalties is already stated. And so instead of trying to create a new crime, my guess is that most of the crimes that would be committed are probably already listed in state law. However, they aren't all necessarily crimes of moral turpitude, and I feel strongly that they should be when they are crimes committed against our election officials.
Got the bill, Mr. Clark? There you go.
Representative Clark, if this works with you, on page 3, the amendment would read, on page 3, line 57.
1 minute, Rep. Faulkner. Page.
Page 3,
I'm ready.
line 57.
Yes, top of the page.
Yes, ma'am. Strike the words poll watcher, comma.
I consider that a friendly amendment, Judge Hill.
I would offer that at this time, then, your Judge.
And Joyce, she says she considers it a friendly amendment. The amendment is offered. Is it seconded? Second. All right. Is there any discussion on the amendment? Okay, all in favor of that amendment, please say aye.
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 So, Ms. Clark, the bill is back to you as now amended. Are you ready to go forward?
So move.
Thank you, ma'am. All right, is there a motion to give the bill as amended a favorable report? Mr. Simpson, is there a second?
Second.
Thank you. There's a motion second to give Ms. Clark's bill a favorable report as amended. Any further discussion? Seeing none, all in favor say aye. Any opposed? Ms. Clark, favorable report as amended. Thank you so much.
Thank you,
Appreciate
Mr. Chairman and committee.
Representative Hassel.
I'd like to thank the chair and the members for bringing this bill. This is HB 260. This bill will allow the state to prosecute juvenile offenders for a crime committed on a military basis. So when a juvenile commits a crime on a military installation, only federal authorities have jurisdiction to prosecute the case. This bill will give the state the authority to also prosecute these cases, allowing more efficient and timely resolution of juveniles' offenses on a military basis. I would like to ask for a favorable report.
All right, hang on before we get there. Because you and I have talked about an amendment.
Yes.
Let me talk about the amendment that Representative Hassel and I have talked about. Basically, what it does, if you look on page 16, line 1, line 16, page 1, line 22, page 1, and line 34 on page 2, the word juvenile is in there. And what this amendment does is remove the word juvenile and replace it with the word child.
Yes,
what you're
but
talking about is a child.
Well, I found out that talking again with some people that we don't have to change it. It passed in the Senate, so we can disregard the amendment if that's possible.
Suits me. I will pull the amendment. We certainly don't want to do anything that conflicts with what the learned members of the Alabama Senate come forward with, right? No, I'm fine with that, Mr. Hassel. I'm fine with that. That's no problem. Okay, is there any questions on the bill? Do I hear a motion for a favorable report?
So moved.
Is there a second? Okay. We got a motion and a second for a favorable report. All in favor, please say aye.
Aye.
Representative Hassel, you got it. Favorable report on HB 260. Thank you.
All right, thank you. Thank the members.
Mr. Representative Faulkner, you got 363. Doesn't matter? No, it doesn't matter at all.
All right, members, a friend of mine, parents were killed when a drunk driver struck the rear end of another vehicle on the opposite side of a highway that had a family in it, sending the family careening across the road. The family and my friend's parents were all killed. The drunk driver, it was a habitual drunk driver that rammed into them, and that was the impetus behind a couple of bills I've dropped recently, this being one of them. In speaking with some folks, it looked like our law could use some clarification with regard to what was needed to be manslaughter and even murder in order to prosecute people that had taken the life of another person. So this is, I want everybody to be clear, this is talking about when someone's life has been taken by a drunk driver. And I have worked, and I want to thank Bill Lindsay working with me on this and bringing an amendment to my attention and to to Chairman Hill that I think will help and make our law more clear. And I know Bill is here in the audience if y'all had further technical questions about this, but that is the intent. And then the amendment does change it. They told me this would make it better if we had this amendment on here, and I consider it a friendly amendment and am happy to take it. And I think, Judge, you probably can explain the amendment better than me.
I have a question.
If I got it, but are you going to offer it, David, or am I?
Sure.
I mean, I'll be glad to. It doesn't matter.
I would offer it, and it's replace lines 84 through 85 on page 3 with the following. He or she operates a motor vehicle in violation of section 32-5A-191 and causes the death of. And then replace line 87 on page 4 with the following. Little sub A, he or she has one or more prior driving under the, and then on replace lines 138 through 145 on page 5 with the following. He or she operates a motor vehicle or vessel in violation of section 32-5A-191 or 32-5A-191.3 and causes the death of another person with the vehicle or vessel. That's the amendment I would offer.
All right, so let's just, that's the amendment. Is there a second to the adoption of that amendment? Thanks, Mr. Starnes. All right, there's a motion and a second to adopt this amendment. Is there any questions just on the amendment? Okay, seeing none, all in favor of giving the amendment of adopting the amendment, please say aye. Any opposed? Okay, the amendment is adopted. All right, Mr. Faulkner, back to you with your bill as adopted. Are there any questions on the bill as amended?
I have a question, Judge.
Sir, who? Okay, I'm sorry, Mr. Tillman, please.
Mr. Faulkner, what is the difference between your bill and a extreme indifference murder charge?
Let me, if you don't, OT, can I get Bill to, Mr. Chairman, would it be all right to have?
Absolutely. You can get your lawyer up here to talk about it.
That'd be terrific. This is a criminal issue, and
in a game show that's called Phone a Friend.
Do what?
He's phoning a friend, that old TV show.
I got you. You're right. Certainly. Go ahead, sir.
Good afternoon. My name is Bill Lindsay. I am the Traffic Safety Resource Prosecutor for the state of Alabama. Thank you for your question. So what the difference between manifesting extreme indifference and what this changes in the murder statute is we have to argue now if we're charging a murder in an impaired driving traffic crash where there is a fatality, we have to argue at this point based on case law. It's a case called Allen v. State is what we typically use. And we have to go through and highlight there could be a variety and a variable of different conditions that would rise it to the level of murder. What this does is this sets outline definitive for prosecutors and for the prosecution and for the defense that if they are a repeat offender, meaning they have at least one prior conviction and they have a BAC of 0.15 or greater, then it could be a murder charge. With the manifesting extreme indifference, we would have to go into greater detail. We would have to go into a large amount of detail in regards to the BAC. Allen does not. I do not believe in the Allen case, if my memory serves me correctly, of that case. I don't believe there's a discussion about prior conviction. There's a discussion in a Kentucky case that they reference back to about prior convictions, but I think the Allen case did not refer to convictions. What it did was the high level of intoxication in that case. It also referred heavily to the driving actions of the vehicle. There were some witnesses that saw it not only run off the road, but also travel in the opposing lane for a significant amount of time. There was some weaving in and out of traffic, I believe, in the Allen case as well. It then goes into the detail of how you would prove a DUI. And I think you're familiar with DUI, but the defendant in that case did poorly on the SFSTs. He had slurred speech, red watery eyes, and I'm trying to think what other condition that they noted in the case. In the Allen case, they said that is a close case. So this is just giving a more definitive bright line for the for all the attorneys and parties involved to go, is this should be murder or should this be manslaughter?
Okay, so let me give you an example. Defendant driving 100 miles per hour, causes an accident, kills 2 people in the car, blood alcohol level 1.5, charged with extreme indifference, murder.
Could, yes, sir. Yes, sir, it absolutely could. It would not fall under this new subsection because he did not have any prior convictions.
Okay, so this pertains just to prior convictions, or?
The language that is being added creates a new subsection, and if they have if they're a repeat offender, meaning they have 1 or more priors, and they have a BAC of a 0.15 or greater.
Okay.
Spence.
Why did we pick 0.15? Legal limit in Alabama is 0.08, so we're almost double the legal limit. Why would we go that high?
So the presumption is at 0.08. This legislative body picked 0.15, and I can't remember the exact year that we added kind of an quote unquote enhancement in the DUI law. So under the DUI statute, we doubled the mandatory minimums if the defendant had a BAC of 0.15 or greater. And that was the 1.5 was used in this bill in Representative Faulkner's original bill. So I stayed with that, but I would hazard a guess that the reason that 1.5 was selected was because in the previous DUI, in the current DUI statute, we used that 1.5 threshold to start doubling the minimum punishments in those cases.
I'd asked Faulkner, and he didn't know why, so that's why I was asking you. So.
Wait. But yes, sir. Nobody talked to me about the 1.5. I will tell you the last time I looked at the general average result of a breath test here in the state of Alabama for just alcohol, it's a 0.13. So that's the average in our state. So 1.5 would catch those that are more. That are higher.
What you're really saying in this, the way I read it, is that 0.15 is by definition indifference, extreme indifference per se.
Yes, sir.
Okay. That's exactly the way I read this bill. I understand that, Mr. Pettis, but Highway Patrol, I got you. Go ahead, ma'am.
Just one quick question. Do we have a separate, similar statute that deals with just being under the influence, not of alcohol, but of drugs?
So the DUI statute in Alabama covers all drugs. So subsection A1 and A2 deal with alcohol. A3 deals with controlled substances. A4 is a combined influence of controlled substances and alcohol. And then A5 is any other substance which impairs the mental faculties.
So in this bill, we have, I'm sorry, I should have read it more carefully, but we have a section in here that would catch somebody that's has a prior conviction and is under the influence of something else.
I'm not sure I understand your question. So the murder subsection, the subsection being added to murder is obviously going to pertain only to alcohol offenses. So the 0.15 BAC is the blood alcohol content. So I'm sorry I said that.
Okay, that's my question. We don't have a separate, similar.
No, there is in the state of Alabama there is no presumption for any other drug other than alcohol. We did not have those presumptions. And I don't know that scientifically there's a basis to form those presumptions for any other drug other than alcohol because of the differences. Alcohol is a water-soluble drug, And all the other drugs that are common on our roadways are fat soluble, so they don't stay in the blood system as long as alcohol does.
I got you, I understand. Mr. Simpson.
Make a motion for a favorable report.
As amended.
As amended.
Is there a second? Second. All right. There's a motion for favorable report as amended. Any other questions? All in favor say aye. Aye. Okey-doke. Thanks a lot.
Thank you, Bill. And Mr. Chairman?
Sir.
Personal privilege to members of this committee. I need your help on the floor because I'm not going to have Bill. He won't be able to come on the floor.
I will volunteer, Mr. to go down there and do the same for you. Almost out the door. I know, but just a little slow. All right, listen, the last bill that we've got today is HB 335, and let me talk to y'all about it for a second. Right now, a lot of what we do in this state are tax sales as opposed to tax lien auctions. I was approached by our revenue commissioners, and they asked me to bring this bill. It was actually drafted by a lawyer in Columbiana named Bill Justice. Bill works with that particular group and does a lot of work with our revenue. So let me go through this in a heartbeat. A tax lien is when it is formed when an individual fails to pay their ad valorem tax. And after a certain point in time, just like your taxes now, they come up for sale. The tax lien is auctioned off. There's notice given to the individual who has not paid. Your taxes are due in October. They're not late until the end of December. If you do not pay them, at some point in time, the state auctions these off. This requires a 30-day notice to be given prior to the point in time that sale is made. If an individual were to buy that particular tax lien, not only must he buy that tax lien, but he must buy every tax lien that predates that one. So you would get it coming into at one point in time. In the event that no one did this, then the revenue officer of the county would have the ability to privately negotiate with someone to buy that tax lien. However, they'd still be bought for the same money, the same delinquency. It gives to a wide number of people, not only the owner, but any family member, lien holder, mortgagee, the right to redeem, and that right of redemption is in there. It prohibits the individual that buys the tax lien from going onto the property until such time as he gets basically what we used to call a tax deed or a certificate from the clerk, which would take a bill to quiet title, and it would be a 3-year period before that could be done. So it gives an ample period of time for an individual who loses their land by virtue of not paying their taxes to come back in, buy it, redeem it back, and not allow someone to go in there and do work on it such that it would raise the cost to the individual who wishes to redeem for doing that. So this is, in essence, folks, is to do a couple of things. It is to simplify the way that our revenue officers now handle this. It is to keep this property in the hands of our local revenue, our county revenue officers, instead of putting it into basically a holding system that is within the state. We have thousands of pieces of property right now just being held by the state of Alabama that have not been redeemed. This would hopefully put more of those properties back in use and back in a situation where taxes could again be assessed on them and paid, and it would simplify the way that it is done as far as our revenue officers or revenue officials are concerned. So I realize that's a pretty brief explanation of a pretty involved bill, but it is an attempt to make it a little bit simpler. It also allows the offering into evidence and the acceptance into evidence of the tax officers, officials, records that they keep, and that would be prima facie evidence of that which they've done. I do have an amendment on page 329, line 329, page 12, that this would deal with someone that if they did go into possession, even though they've been told they cannot enter the property, and they do damage, it would not give them immunity that this bill would do if they followed it. So I would ask that we adopt this amendment.
Second.
All right. Is there any discussion on the amendment? It's really, they have immunity, but if they go in and do something and cause damage, it removes that immunity. It's what it amounts to. All right. All in favor of the amendment, say aye.
Aye.
I'm going to offer the bill as amended. Is there any discussion? Yes, sir.
Eddie, what happens to the proceeds from the tax sale? Where do those funds go to?
Well, initially, if it's strictly the tax, it's the lien, it would be only those proceeds that would be owed on the taxes. So consequently, they would go to the.
And there's not any overage.
They would go to the revenue. Part of it is to try to avoid that, Tim. Okay. So it would go back into the county stream of revenue, and if you were to redeem it, then you would have to pay that plus interest, plus the recording type costs that the expenses that go back into doing this. Okay. I think it'd actually be an easier and cheaper way for people to redeem their property if they were so disposed to do so.
Mr. Chairman?
Yes, sir.
Go ahead.
Go ahead. They'd have to hold it for 3 years and then file a bill to quiet title. All of that is an opportunity to give that individual who the property who did own it an opportunity to come back in and redeem.
But they bought it and they came to me, so they will get to live there for 3 years after it's sold without paying any taxes.
The individual for whom the property was sold, yes.
They bought it.
The people that bought the tax lien could not enter the property until they got a deed from the court, which they would do by a bill to quiet title.
So that's 3 years.
Yes.
So for 3 years, there's still not no taxes being paid because the people who bought it, are they gonna have to be paying the taxes?
They're still assessing. Yeah, they're still occurring. So I would assume if they went back in and bought what's going to happen is the individual that buys this tax lien is going to end up with a bill of quiet title, and they're either going to pay those taxes at that point or they're going to pay them year by year. The object is to try to get this property back in the stream of revenue, and it's just not in it right now.
3 years or so. How is it? How long is it?
It used to be 6. Now it's 6. You got to hold it. And a tax deed, to get a tax deed, you got to hold it 6 years. This is lessening that number and not allowing someone to buy it in at a price higher than that which is owed, that's actually owed to the state, to the county.
What happens if there's not a suit to quiet title? Does that mean
it would revert back and you'd start over?
It'd revert back to the original landowner?
Mm-hmm.
Okay.
And it would start over. And it would actually go revert back to the county. It would because see the revenue officer is going to place this lien, and the revenue officer's obligation is to sell it. So he's going to put it back in that stream.
Mr. Chairman, last year, I think, you sent a bill to Civil Subcommittee that had massive passion on each side dealing with redemption. It was an ALI bill. I think Tim actually was carrying it. What does this have to do with that?
Similar, but this is one that comes strictly out of your revenue commissioners, and it is to streamline their job and what they do and leave that property such that it is held by them in the county as opposed to held in the state, and puts on them the obligation if an individual, if it is not bid off, to find somebody to buy it for the taxes.
If I may make a comment.
Yeah.
The bill that we had last year was a tax sale bill. This is a tax lien bill. And the county commission's group was opposed to the other one, the tax sale bill, because they wanted to come back with this tax lien bill.
The tax lien bill truly is simpler and more streamlined than that tax sale. There's just a lot of hoops that you go through on a tax sale.
And I think most counties are now,
counties use it.
and now you said revenue commissioner. If we don't have a revenue commissioner in my county, would we have a tax assessor? Or do we have a tax collector?
My guess is this would come under the tax collector, but
It'll
our
be-
revenue people are all one.
It'll be collector or tax revenue,
Yeah.
one of the two.
Who would sell you? I bet you it's a tax. I don't really know about Jefferson County, but my guess would be it's the tax collector who would be in charge of making this sale.
Actually, the probate judge. I think it's the probate judge.
Probate judge?
Yeah.
Okay. In my county, it's the revenue people. All right, we got a motion favorable for a motion. Do we need a second? I need a second.
I gave a second.
Thank you. Motion second as amended for favorable report. All in favor say aye. Any opposed? Okay, thank y'all very much. Good meeting. See y'all next week.